Hello, this is Nancy Cheshire. I'm one of the members of the COPE Council, and I'm very happy to welcome you on this Friday, April 12th. People are probably on a variety of different time zones, so good day to everyone. I am going to just introduce the webinar today, which is about allegations of misconduct. And we do have a little bit of housekeeping things to do before we get started with that. So our speakers today, who we're very happy to have with us, are Susan Garfinkel, who is going to be our first speaker. She is the Assistant Vice President for Research Compliance at The Ohio State University. Next is Tara Hoke, General Counsel of the American Society of Civil Engineers and COPE trustee. And as I mentioned, I'm the moderator for today. I'm the Editor-in-Chief of Obstetrics and Gynecology and a member of the COPE Council. Just briefly, I want to introduce the core practice, which this webinar is about, which is allegations of misconduct, and just a quick review for COPE. The core practices on this includes that journals should have a clearly described process for handling allegations. However they are brought to the journal's or publisher's attention. Journals have to take seriously allegations of misconduct pre-publication and post-publication. Policy should include how to handle allegations from whistleblowers. COPE's working definition of misconduct in its very broadest sense, and this is taken from a COPE guideline published in March 2012, is that misconduct is any practice that might affect the reliability of the research record in terms of findings, conclusions, or attribution. So that's the very broad definition. Allegations of misconduct may be raised by a journal or author's institution. It has to be, it requires a two-way confidential communication between research institutions such as university or independent research institutions, for instance. These institutions should notify journals if an investigation of one of its researchers' identifies misconduct that affects reliability or attribution of a published work. Institutions should cooperate appropriately with editors so that she or he can determine appropriate responses, and editors should likewise cooperate promptly with institutions if asked to provide information. Journals, on the other hand, the other side of this two-way cooperation, need to inform institutions about possible misconduct per COPE guidelines. We need to provide evidence to support allegations of misconduct if they've been raised, and if misconduct is found at the institutional levels, journals need to be prepared to issue retractions or corrections. So at this time, Susan Garfinkel is going to lead us into a discussion. Susan?
Yeah, great. Okay, thank you. So I just took control of the screen, so I should be able to move through the slides. So I work at The Ohio State University right now, and I'm going to talk to you a little bit about research misconduct from the perspective of the institution. Obviously, in 10 or 15 minutes, I can't get very in-depth. These are very complicated processes, but I'll give you like a brief overview of what goes on. So this first slide is just to show you the institution's process. Every institution has policies in place, especially if they receive federal funding, which most institutions do in the United States, or big institutions. They are required to have policies for handling allegations of research misconduct, and it's in compliance with the federal regulations. So institutions do an assessment, an inquiry, and an investigation. The assessment is only to see if the allegation of research misconduct fits the definition and is specifically and credible to move on to an inquiry. So the bar in an assessment phase is pretty low. It's just receiving the allegation and determine if it fits the definition. The inquiry inquiry is usually done with a faculty-led panel that does a preliminary fact-finding and gathers information to indicate whether the allegation has substance. If it has substance, it moves on to an investigation. If it does not have substance, then the process is stopped at the inquiry. If it does move on to an investigation, there's a second faculty-led panel that actually reviews all of the evidence in depth to make a decision about whether research misconduct occurred or not, and what the recommended corrective actions or sanctions should be. So in handling research misconduct, actually the definition from the federal regulations and what most institutions follow is pretty narrow. Under the regulation, it includes fabrication, falsification, and plagiarism in proposing, performing, or reviewing research, or in reporting research results. This does not include honest error. It does not include authorship disputes and many other questionable research practices or detrimental research practices that have significant effects on the research or in the function of the laboratory, but do not rise to the definition of research misconduct. So who at an institution handles research misconduct? Many of you probably know if you've contacted a U.S. institution, it's the Research Integrity Officer. We call ourselves RIOs. The Research Integrity Officer is usually located in the Office of Research. The role of the RIO is not defined by regulation. What has happened over the last 20 plus years is that the regulation says that a person at an institution has to be kind of the point of contact for dealing with allegations of research misconduct. And the RIO position kind of grew out of this requirement that somebody has to handle this process. So the RIO administers the institution's policies and procedures and assures compliance with the federal regulation. The RIO is not a decision maker. The RIO remains neutral and objective and unbiased, which sometimes can be difficult because people pull you in all kinds of different directions. But you have to remain neutral and objective in order to ensure that the process is fair. The RIO interacts with the federal agencies and also with the journals and the editors. So many of you probably have had interactions with RIOs at different universities. And the RIO's office, in addition to handling allegations of research misconduct, many other of the concerns, the QRPs or the detrimental research practices, the DRPs, as authorship, mentoring, data management, come into the RIO's office and then have to be dealt with and referred out to the appropriate office or college or department that can handle those concerns. So as I mentioned, at Ohio State, the RIO is located in the Office of Research, in the Office of Research Compliance. There are sometimes on some institutional websites, it's difficult to find out who the RIO is because they might have different names. Some are directors of research compliance, some are directors of research integrity, some are associate vice presidents of research compliance. There's lots of different names, but in general, an Office of Research, an Office of Research Compliance, an Office for Research Integrity are the types of offices that will usually house the person who actually deals with allegations of research misconduct. Because we have recognized, before I came to Ohio State, I worked for the Federal Office of Research Integrity, the ORI in the DC area. And as a federal employee, we saw what was going on over the country. And one of the problems was that the RIOs were hard to identify in different institutions. Well, the RIOs have an Association for Research Integrity Officers called ARIO. I am providing that website on this slide. And if you're looking to, we're trying to work with ARIO to try to get some kind of directory of RIOs across the country. So when journals have problems, they know who to contact at the institution. Okay, so all of this that I'm telling you about what's going on at an institution, what does this really mean to you as journal editors? I think to go back a step to say how this is all affecting you, it's good to understand the confidentiality provision in the federal regulation. And the reason is because these kinds of confidentiality issues are incorporated into every institutional policy on handling allegations of research misconduct. So the federal regulations, section 93-108, talks about confidentiality. And it basically says that proceedings are limited to the extent possible to those who have a need to know in order to run a thorough process. There's a second provision that says disclosure is limited to those who have a need to know to carry out a research misconduct proceeding. So what does this mean? Do journal editors and publishers have a need to know? Well, the answer to that is it depends who you ask. Some say yes, some say no. The issues that have developed with the coordination between institutions and journals and journal editors and publishers is that it's very hard to identify or to come to an agreement of when is the right time that a journal should contact an institution and who should they contact, and the same is true for an institution contacting a journal. So what's the right time? What information should be given? If you're in the middle of a research misconduct proceeding that's supposed to remain confidential, there are some universities that say we cannot release any facts about this. In the same way, the journals have their own confidentiality restrictions that prevent them from releasing some information. So it's very difficult to come up with a good answer, but the community really needs to determine what is the best way to handle these kinds of interactions, because it's actually causing a lot of problems for institutions and also for journals. So one way of approaching this that I have thought about is that if you think about what are the elements to prove a case of research misconduct, when you make a finding of research misconduct, there's three elements that are involved. The first is that there be a significant departure from the accepted practices of the relevant research community. The second is that the misconduct has to be committed intentionally, knowingly, or recklessly by the respondent. And the third is that there has to be falsification, fabrication, or plagiarism, which is FFP, and proven by a preponderance of the evidence. So the first part is the more easy part. To prove something is false or fabricated or plagiarized, nowadays there are lots of different tools you could use. Authenticate or any other plagiarism software can identify an overlap in text. And image analysis software and tools are very convenient for locating when an image is manipulated or when bands are cut and pasted in an image. It doesn't take too long to figure out falsification, fabrication, and plagiarism. The difficult part of a research misconduct proceeding is figuring out who did it and what were they responsible? Did they commit this intentionally, knowingly, or recklessly? Because you're trying to prove a respondent was responsible by basically trying to find evidence to prove that that person was the one who falsified an image or falsely reported data, or just knew that that data was false and reported it anyway, which is the hardest thing to prove. What's going on in somebody's mind. So you use circumstantial evidence to build a case about what somebody thought or was thinking at the time the research misconduct occurred, and it becomes incredibly difficult. So one of the reasons these processes take so long is trying to actually determine this part of the research misconduct. To make a finding of research misconduct, it's this part that takes a long time. So if a journal finds out that if an institution finds out that there is falsification, FFP, falsification, fabrication, and plagiarism, is that a good time to alert a journal? And what will the journal do once the institution notifies the journal? Suppose an institution says we want to retract a paper. What would be the questions that a journal would ask? Would a journal ask, well, what's going on? Was there an investigation? And an institution is not going to be able to make those kinds of disclosures to the journal in the middle of a process. So there's a lot of unknowns. Journals aren't comfortable with it. Institutions aren't comfortable with it. But I think if there's any way that we can come to a decision and a consensus of what information is required to be released and when is the best time to do it throughout the process, I think that journals and institutions will have an easier time. And once the communication starts, there will be a trust that develops between these different groups. and having that trust will allow people to work together in a better way. I saw that happen even within the Rio community. When Rios first got together and started networking, there was a lot of issues about what you can say to another Rio at another institution. But as you develop this trust in the communication, the lines are open, they're hypothetical, often hypothetical discussions, but you can develop best practices and talk more openly about what the issues are. So I think that's the end of my presentation. I'm going to give the screen back to Nancy.
Susan, thank you very much. That was very helpful. So we're going to move on to Tara Hoke.
All right. Thank you, Nancy. Thank you, Susan, for a wonderful discussion on from the perspective of institutions. For my part, one of the things that I do with COPE is that I serve as the chair of the Facilitation and Integrity Committee. And so my role today, or my goal here today, is to talk a little bit about F&I, what we are, what we do, and how that ties into the discussion about today's subject, allegations of misconduct. But before I go into F&I specifically, I wanted to preface this talk with a discussion about what I see as sort of the principles behind investigations of misconduct and what your role is as a scholarly journal editor or publisher, and above all as a COPE member. All right, so you saw this earlier, the slide was put up before, and here it is again. This is COPE's core practice on allegations of misconduct. And what does it say? It says journals should have a clearly described process for handling allegations, and they have to take seriously allegations, both pre and post publication, and also whether they're from a whistleblower or from an anonymous whistleblower above all. And perhaps if you would come at this as, you know, a complete novice to publication ethics, or if you were coming at this with a blank slate, you might think, well, okay, that's not terribly instructive in and of itself. You know, it's saying you have to have a process, but it doesn't really give you a lot of guidance about what a process would entail. You know, clearly, okay, so if you make a snap decision, I mean, that's not a process. But how much process is required? When can you say, okay, enough process is enough? So that language in and of itself may not be, you know, might not resonate with you. But for me, and I come at this from the perspective, acknowledging my background, I'm an attorney and an attorney in the United States under the American legal system. This language to me resonates most, or is most meaningful to me, as another way of articulating what we call due process. I keep losing, there you go, due process. So what is due process? It's probably a familiar term to people who live in the American legal system. Fifth Amendment to the U.S. Constitution says no person shall be deprived of life, liberty, or property without due process of the law. But it's not a concept that's unique to the U.S. law, although the terminology might be a little different elsewhere. I've heard it in English law, it may be referred to often as natural justice. In Europe and elsewhere, it may be just more generally referred to as the right of a fair hearing. But what does it fundamentally mean? What it fundamentally means is, if you have the responsibility, if you have the authority to make a decision that's going to deprive someone of something meaningful, or has the possibility to cause harm to another person, then you have a responsibility to ensure that that decision that you've taken adequate steps before making your decision to make sure that it's a reasonable decision. That doesn't necessarily mean that it's going to be a decision that everyone's going to agree on, often not. It doesn't even really mean that the decision always has to be the correct decision. But what it does mean is that you've taken steps to prevent or to reduce the possibility that the decision is somehow either biased, arbitrary, or just fundamentally unfair. So we all know what the word process means, and again, that's explanatory. But obviously, the operative word here is due. What does it mean to have due process? As I said, if you're making just a quick decision, or if you're literally flipping a coin, that's not due process. But I'm sure every one of us has experienced cases where it seems that something has been processed to death. You have questions, you have responses, you have objections, you have more questions and decisions, and a process. Again, you could process something until there's never a resolution, and that's not satisfactory any more than having no process at all. So where do you draw that line? And again, I'm going to look to the legal system, and let me say I don't intend to turn this into constitutional law, U.S. Constitutional Law 101. My goal is not to make you budding attorneys. I don't want to put myself out of a job, but what I want to do here is, it's not an exaggeration to say that the legal profession has spent literally hundreds of years trying to determine how much process is enough. And so I think some of the guidance they've offered is actually instructive, and it may be helpful to you if you're looking at your processes, if you're developing a new process or examining the adequacy of your own processes. Again, this is a good sort of helpful way to apply the knowledge from one profession into what works for you. And so the prevailing test from the U.S. legal standpoint it hails back to a U.S. Supreme Court decision from the 1970s, and it said, well, due process is a balancing test based on basically three factors. And the first one's fairly obvious. What is the degree of interest that's going to be affected? How severe is the consequences of your decision? Obviously, if the worst case scenario is that somebody's going to be annoyed at the step you take, that may mandate considerably less process than a decision that has possibly severe consequences for someone's reputation, their livelihood, financial implications. So along a spectrum, what is the degree of harm that could potentially be caused by your decision? So that's the first factor. Second factor is, what's the chance of you looking at your process, looking at the process that you follow right now? What is your likelihood of getting the question wrong? What is your risk of error? How uncertain are you going to be in your decision after you follow the process that you follow? And then balance that against what would be the benefit of additional procedural safeguards. So if you're following a process, and okay, you could take another step, but that second step isn't necessarily going to isn't likely to give you any more certainty than your current step, then maybe that's a suggestion that your process right now is sufficient, that you don't need to add those steps because they aren't really going to add value to the discussion. And then the final of the factors, and it is an important factor, is your capabilities. We all wish possible. I mean, if everybody had the financial and the volunteer resources or the financial resources, the legal resources to have an investigative team that does nothing but administer complaints, that would be wonderful. But realistically, that's often not the case. So balance your personal circumstances. You are allowed to weigh those in a consideration of what process is adequate. But on the flip side of that is again the fulfillment of your function, and again, part of taking it seriously is understanding that you as a journal and as a COPE member have an obligation to preserve the integrity of the scientific record, and also just sort of the practical, financial, reputational merits of your journal and your publisher. Again, if you are perceived as the publisher or journal that doesn't take seriously or doesn't address issues of misconduct in papers that you publish. So this is sort of the spectrum of balancing factors that you should be thinking about if you're looking at a new process or looking at enhancing your own process for reviewing allegations of misconduct. That said, there is a commonly accepted discussion of what's considered to be due process, and Susan just gave an excellent illustration of due process from an institutional perspective. And there are generally considered to be three elements that are essential in order for there to be due process in an investigation. There has to be adequate notice, an opportunity to be heard, and then lastly, a fair and impartial judgment. And I'm gonna break those down a little bit. Okay, so what does it mean by adequate notice? Well, first one is kind of a perspective thing, really. Are the rules being enforced clearly expressed? We all know that there are professional and scientific and research norms, but it's always more difficult to fall back on a norm, and better to have clearly written policies that apply to your journals that you can point to, clearly expressed policies on the availability of primary data, on what is required in terms of informed consent, what your definition of authorship is. having those rules in advance makes it easier to enforce those down the line. So second is, do the people involved understand both the charge and the process to be followed? And this is true, often we focus on, in due process, often the focus is on the person who's accused. But it's also important to note that the person who is making the allegation also has a stake and also has a possibility of being harmed. Sometimes that harm may be a little abstract, but sometimes it's very tangible. A person who believes that their work has been plagiarized or their credit has been denied. And then, of course, the last part of adequate notice, and I said is the decision clearly communicated, but really is communication appropriate at all steps of the process? Do people understand, if there's going to be a time frame set for them to have a response, what is that time frame, and what are the consequences of them not responding within that time frame? Letting them know where they are in the process and what their role is helps them to meet basically the next criteria, which is the opportunity to be heard. And as I said, obviously the most important aspect of opportunity to be heard, do they have the ability to make their case? You're not making a purely one-sided decision. You're looking at both parts of the case, such as it may be. You're considering all interested parties and their perspectives. And this is an important. Is the evidence appropriately shared, and are people giving adequate time for response? I know we've had discussions about confidentiality, and sometimes we talk about confidentiality of the complainant, but it's really important that if you're making a decision and it's again, it's going to be a harmful decision to say an author or somebody who they need to know what you're making a decision on. If they spend their time disputing an allegation of plagiarism, when what you're really looking at is a complaint of manipulation, data manipulation, then obviously they're not really adequately being heard because they haven't actually really understood what the case is about. So it is necessary to at least, again, with the confines of your procedures, to make sure that people have a solid understanding of what it is they're being asked to address. And are there barriers imposed on participation? Hopefully this is not the case, but an example of a barrier would be we're going to have a discussion about this. We're going to have a hearing on the merits of this, and it's not you have to actually be in the town where this hearing is being held in order to share your perspective. That's imposing a huge cost barrier on somebody who doesn't live in that locality or doesn't have the ability to access that hearing. That's not a likely scenario, but again, putting in procedural hurdles or making it difficult for somebody to have that opportunity to participate is obviously the antithesis of sort of a due process. And then lastly, a fair judgment. Is the decision evidence-based? Is applied fairly to all? It doesn't necessarily mean consistent, but fair is important because you don't want to precedents change. You don't want to be again perceptions change. So I wouldn't say that once you've made a decision that X you're necessarily held to it always. But fairness is the fundamental consideration. Is the arbiter neutral? Is this a person that has a stake in the decision? And obviously, is it made a good faith? If there's a predetermined result that something is or is not misconduct, then really there's no fair opportunity for somebody to be heard from the start. So how does that tie into F&I? Well, F&I is it's a volunteer committee at COPE, and our role is to look at procedures followed in a case. Normally we hear from somebody, in fact, we only accept cases from somebody who has gone through a process of submitting a complaint or raising a concern with a journal or with a publisher and has followed that process through to their end and is in some way dissatisfied with that result. We're not a police force, we're not a prosecutor, we're actually intended to educate. Sometimes that's educating the person who submitted the complaint, often not well-received education, but basically an education that says, yes, this is an accepted process. Yes, this was a decision. You may not like the decision, but it's it was a well-reasoned decision. But ideally, if necessary, our goal is to educate our members if there is something where we thought that there was an opportunity to improve. And again, we're focusing on process, not on the substance of the decision. There may be times when we disagree with a factor. There may be frequent times where we disagree with the actual decision that they reached. But as long as they made that decision following a due process with adequate consideration of the factors and giving a fair opportunity for all to be heard, then again, that's sort of within the realm of editorial independence with editorial judgment. That's not where we're looking to intervene. That said, there is an integrity end to this committee. When people join as COPE members, they follow. They commit to following our core practices, our principles of publication ethics, and our membership is we consider them to be, we consider this to be a hallmark of journals with outstanding reputation, with outstanding commitment, and that is threatened. The integrity of that is threatened if we accept members that are just words and no substance. And so we do look at cases, rare cases where somebody has joined as a member. We would consider that if we saw sufficient concern that they weren't actually adhering to their expectations, then there is a mechanism for us to take action about that. Again, rare in practice, fortunately. This is just a quick snapshot. So F&I has been in existence for, I guess, about 1.5 years now. And this was a snapshot of really about a year's worth of cases. We had about 70 cases over the course of November 2017 to 2018. And if you look at this list closely, you're going to see that, frankly, I actually thought this number was a little low. I was a little surprised that about half of the cases that come relate in some way to allegations of misconduct. Obviously, the biggest one, concerns about integrity of the published work, either data manipulation, the obvious frauds, invalid conclusions, manipulation of the conclusions, all of those tie into the concerns about integrity of published work. Concerns about a retraction decision, and this is usually both sides, probably slightly more common an author who disagrees with a retraction, but occasionally a concerned reader who feels that a paper should be retracted and is disappointed when the journal decides ultimately not to. Plagiarism is on this list, salami slicing, which may or may not be misconduct versus an honest error. Ethical concerns, again, informed consent is sometimes brought up. About half the cases that we see are allegations of misconduct. And I will say, and I don't have statistics on this, but I would say that probably between 80 and 90% of the cases that we see, we ultimately decide that the journal did follow adequate process. Again, we may not always disagree or may not always agree with the ultimate decision they reached, but we're satisfied in the process that we think that they did hit all the marks. They gave notice, they gave the opportunity to make a case, and they made a decision that's reasonable in the face of the information that they had. But in the course of the 1.5 years, there have been times where we've seen not necessarily sanctionable offenses or evidence of people that are not interested, but ways that there could be improvements. And so I've put down a list of a couple of us put our brains together and thought of the list of what we think are the things that we most commonly see that are areas for improvement. The number one is probably timeliness. Timeliness of responses, timeliness of investigation. Now, I recognize in that sense, you can't control everything, and sometimes authors are slow in responding. Often authors are slow in responding. Institutions may be less responsive than, or they themselves are dealing with the same problems of not entirely being able to control the timeline. And also sometimes it's an expectation issue. 8 hours. That's not reasonable. But at the same time, that is also an opportunity to make sure you communicate your expectations or communicate your time process is still ongoing and that you haven't lost sight of it. Again, there's definite value into communicating properly with people when you're involved in a case. Lack of a clear written policy on an important subject. We often find this, and it does leave journals struggling to deal with something when they maybe their policy on informed consent wasn't really up to par, and now there's a question about whether or not a paper was published that didn't meet this is again the professional norms. Appropriate explanations of decisions. I've seen cases where somebody has sent a response. So somebody submits a complaint and the editor sends a response and says, "Yep, thank you, we've looked into it and we don't see any issues." That's not very reassuring to the person that submits the complaint. That's not really demonstrating that you gave due diligence to the complaint. And so taking care to demonstrate that again, to the best of your ability, you took the complaint seriously, you examined it, you didn't just dismiss the claim out of hand, goes a long way to addressing, again, even if somebody's not satisfied with the result, at least gives them less of a ground for complaining about the decision. Insufficient follow through, and this is kind of related to the next one, failure to address all concerns. Sometimes people submit, frankly, a laundry list of concerns. And if you pick concerns 2 or 3 and say that so you're satisfied but fail to address concern 1, and again, maybe that's just an oversight, but be careful to address all the allegations that are submitted when you get a multi-allegation, and follow through legitimately. If it's a case of something serious and the author gives an unsatisfactory explanation, the discussion shouldn't end there, or you shouldn't be so quick to accept a response from an author that on the face of it should not be satisfactory. Conflicts of interest, as I mentioned, interference with independent judgment. This a lot of times comes in with a society journal, where you'll see an implication that the person that was complained about is somebody with influence in the community or within the society, or there was some sort of suggestion that the person that was making the decision was, again, unduly influenced by an outside entity to make a decision, either to make something go away, or again, just to stonewall a case. Again, not taking care to ensure that all parties are kept informed. Lack of clarity, again, here's a society-run journal problem. Lack of clarity on whose responsibility it is to investigate. There have been times where I've seen, say, there's a society-run journal and there's an outside publisher, and there's a back and forth about which entity bears the primary responsibility for administering a complaint. And then this is not very often, but it does still happen that sometimes people get an anonymous complaint and they don't look into it quite seriously. All right, and I think I'm going to turn this back. I believe that's it for me. So I'm going to turn this back to Nancy.
Super. Tara, thank you. And thanks to Susan as well for her discussion. And now we're going to turn it over to Rachel, who is going to field some questions and pose them to the right speaker. Rachel?
Thanks, Nancy. So please remember to type your questions in the question box. I know we have a limited amount of time today for attendee questions, so if there's one that we don't get to in the time allotted, please know that we'll try to follow up individually afterwards. So Susan, we're wondering if the processes and practices that you've described today are unique to your institution, or if they are more broadly applicable, not only throughout North America, but also globally, certainly given that COPE has members around the world.
Sure, and obviously my background and my expertise is in the U.S. system, but for the U.S. system, it is pretty consistent from institution to institution in what the policies are, in that there is an assessment, an inquiry, and an investigation. Different institutions will be better or worse at handling or implementing the process based on how much experience they have. So what we have seen in the U.S. is that the more funding, federal funding, an institution gets, the more cases they usually get, because there's more people working and more chance of problems occurring. There's nothing unusual about that. The U.S. has had a 25+ year history in dealing with the regulation and becoming established as kind of a leader in research integrity and research misconduct. But the European Union has a system, Canada has a system, many of the independent countries in Europe have their own processes. They're all similar. There are differences amongst all of them. Asia has processes where there is no in certain countries, there's no centralized body that handles oversight of investigations. It's handled at the university, but the university has processes that are followed at that specific university. The biggest question that comes up is having institutions investigate their own faculty. And although there is a perception of conflict of interest in this regard, in general, institutions handle this very well because it's in everybody's interest to ensure that the integrity of the research record and to ensure that their faculty, if they did commit misconduct, that it's taken care of. But yeah, there are systems throughout the world. It's just they're similar, but there are lots of differences from different cultural aspects of each country. Does that answer the question?
Yeah, thanks, Susan. So the next question is, what is the role of a research integrity officer in reviewing errata or retraction notices, especially if the author is corresponding with the journal and the author is requesting the retraction?
Right. So one of the concerns nowadays, from my point of view, is that retractions are being conflated with research misconduct. So a retraction could be just an honest error and a mistake. And an individual author can request a retraction because they couldn't repeat the data. They tried it and it didn't work again, and it could be a mistake. We gave the wrong figure, whatever the issue is. When retractions are done because of research misconduct, that's a different issue. So an author who just submits a retraction, if it's just for a mistake, it's likely that the institution, the administration at the institution doesn't even know about it because there's no way you could track all the publications for all the authors. If the retraction is coming in response to a research misconduct matter, then it's likely that the RIO is either involved in it or has been involved in it or should be involved in it. Sometimes retractions are done by authors to get it out there before a finding of research misconduct is made because they don't want that to be part of the retraction notice. And it's all about the timing of these kinds of things and how long an investigation takes. It's a difficult question to give one answer for because there's so many different variables in it.
Okay, thank you, Susan. Next is a question, what confidentiality boundaries are there with journal communications of concern to authors? What does an author want to post their response to a complaint on their own website? Tara, maybe this is one that you could answer.
Confidentiality, confidentiality is a tricky thing when it comes to investigating the complaints, and I know we all don't want to be tried in basically in social media, but again, to me, it's a balancing issue. For example, often if a complainant may wish to remain anonymous, that's often a confidentiality consideration when it comes to if the person does not have a personal stake in something, but for whatever reason, either they're afraid of repercussions professionally. That's a consideration that I would try to honor when it comes to not sharing information. But beyond that, again, we personally try to share all information and all correspondence back and forth. We have been in sticky situations where somebody has put something to us and asked to remain confidential. And again, there you have to, it always has to be weighed in light of, like I said, the due process aspect of it. If somebody's trying to say, I'll tell you information about this misconduct, but you can't share it with the author, again, it raises fundamental fairness questions. And I think at that point, you kind of have to make it clear that you can't actually make a fair or reasoned decision. Well, again, I don't want to speak in absolutes, but there's always going to be a question of whether or not you can make a fair, a decision that's fair to all parties if all parties aren't operating on a common level of understanding about who and what is identified in the case. I hope that answers the question.
Yeah.
Rachel, I think we have time for about one more question.
Okay, so this one is actually from Trevor Lane, who's a member of COPE Council, but thought would be broadly applicable. Trevor asked, how can journals initiate investigations with institutions if, number one, an author has left that institution where the work was done and reported, and number two, if an author has left the institution where the work was done, but is at a different institution when actually publishing the work? Tara, maybe you can tackle this one to start, or Susan even?
I could, this is Susan, I could talk to you from the institution's perspective. So in the US system, if an allegation is raised about research that was conducted at the university, so I'm at Ohio State, if you raise an allegation to me about research that was conducted at Ohio State has the obligation to actually look into the problem. If the author is gone from the university, it doesn't matter. Ohio State still has that obligation because theoretically the data is supposed to be maintained at the institution where the work was done. That practically isn't always the way it works. A person will take data with them when they leave and they go to another institution. What RIOs in the US do are try to coordinate it so that you can get I would try to coordinate with the institution where the respondent, the person being accused, actually is, and I would try to get that information, the data back so that we could do the investigation. The alternative is that there's an agreement that because the data is all there, it might be easier for the other institution to do it. So the RIOs try to work out the best way to do it. I can tell you that allegations are never ignored, regardless of whether the author is still in the US or it has moved to another country. If the research occurred at the institution will take the responsibility for it.
Great, thanks, Susan. I know we're quickly running out of time, so again, we'll try to follow up with other questions that were asked. There are several here, so thank you all for your engagement. Nancy, back to you.
Thank you. And it is right at an hour since we started, so we are going to stop here. Once again, thank you to Susan Garfinkel, Tara Hoke, and Rachel Safer for their contributions here. Special thanks as well to the Education Subcommittee, Linda Goff, Sarah Gilmore, Seba Moran, and Natalie Ridgway. Thanks for what you do for research, and have an absolutely great day.